So we are very familiar with the facts of each case, and we encourage the parties to just jump right into your legal argument that you will be making. With that, we turn to the first case before us, and that is case number 127564 from Leavenworth County, State of Kansas appellee versus Stephen Wayne Cox appellants. Would the parties please state their appearances?
May it please the court, appellant Stephen Cox appears by counsel Kate Zigtema.
May it please the court, the state appears by Principal Assistant Solicitor General Natalie Chalmers.
Thank you very much. And counsel, would you like to reserve any time for rebuttal?
3 minutes, please.
3 minutes are granted.
Thank you.
With that,
And the court's ready. Today, I'd like to focus primarily on the attempted criminal threat conviction that was the focus of our brief. The first issue in my brief was that the district court erred by applying a change in law, but I think that's pretty well settled by Murdoch and Smith, so I'll just jump into the merits of our argument on that one. I think it's important to break this issue down into two questions. One, as a matter of law, is attempted criminal threat within the bounds of 216810 D9 as a crime defined by a statute that's been declared unconstitutional. The second part is, as a matter of fact, have we carried our burden or at least established that we should remand for additional fact finding on the underlying conviction? It's sort of a daisy chain argument, but I think it's appropriate for crimes such as an attempt. Attempt is not a standalone crime. You must attempt to commit a crime, and all crimes are defined by statute. So an attempted criminal threat is going to be subject to Bodiger because it cannot be defined without that provision of the criminal threat code, or sorry, the criminal threat statute. So as a matter of law, I think you have to look at both of them together, and that an attempted reckless criminal threat can in fact be subject to the Bodiger exclusion and the exclusion defined by Smith underneath that plain statutory language.
counsel, could we talk about what an attempted reckless criminal threat? How is that even possible?
Well, one, it is kind of a legal fiction. You cannot have a jury trial about attempted reckless criminal threat. You could stretch the facts to make it work, but I think that it's more important to note that we operate on legal fictions for pleas, and legal fictions are permissible. So it really is upon the state in amending the complaint and negotiating the plea agreement to clean up their language, to clean it up, to make sure that it is clear that it is the intent alternative means. We've had alternative means for a very, very long time before Bodiger. So the fact that we have complaints that just copy pasted both provisions, it's kind of a mess of the state's own making that they have to resurrect once we start these challenges after Bodiger.
But if we're permitted to plead to a legal fiction, can we not plead to any legal statute?
I think you can, Judge. I sort of joke about plea agreements because you don't really get to appeal them. It's all fun and games until somebody files a notice of appeal. Most plea agreements, hopefully the court follows the plea agreement, client serves their agreed upon sentence or probation, and this is not an issue that comes up for review. I think that leaves this sort of gray area that we function in where they wouldn't have had a right to appeal because the plea agreement was followed. Nobody challenged it. Everybody agreed to it. It's not a jurisdictional issue that we could say, it doesn't matter what the parties agreed to. Parties agreed to a legal fiction, and that is the conviction of record for the client based on his agreement. Did that answer the court's question?
So then if you're permitted to plead to a legal fiction, serve time related to a legal fiction, can that then be used, a legal fiction be used for your criminal history?
I think it can because you pled. You've sort of waived the challenge to that underlying legal fiction. Unless the statute becomes unconstitutional, then, which is where we get into the statutory things of how we score criminal history. So if you plead to a legal fiction, you have entered in an knowing contract, you've waived your rights, and that's what you're stuck with. I don't think that you can come back and challenge that legal fiction as a invalid conviction because you have received the benefit of the bargain, which is what Judge Atchison's dissent really goes into a lot.
But you believe that if that legal fiction is unconstitutional, then it should not be used for scoring criminal history. So you separate those.
I do, because it comes back to the statute. If they amend the sentencing guidelines and say we're not including legal fictions in a criminal history score, that's a different animal. Now we've got a statute to interpret. It comes back to the fact that they said a crime defined by a statute that has been determined unconstitutional. That is what we have here. Even though it's a legal fiction, that portion of the statute was unconstitutional under Botiger. So it's not so much that it's a legal fiction, it's that the parties reached an agreement to plead to a crime defined by what has since become unconstitutional.
Will you shift gears maybe to the factual side of it? So, you have the preponderance of evidence to show us that it was reckless, and it looked like you cited the complaint, the amended complaint, and then the PCA. Tell us what about those documents meets the burden, and then maybe also cover, what you would expect to offer if this was on remand.
I'm glad the court brought that up, because in preparing for argument, I took a second closer look at 2168-14, which is sort of the statutory enactment of the modified categorical approach. And what I noticed when I took a closer look at subsection D, they actually have a narrower class of documents to look at that we can add to an appellate record to pursue these appellate challenges. So that maybe goes back a little bit to the part I skipped over where we think the district court erred and Smith cleared that up. But we can't add all the things that have ever been mentioned in case law. We're limited to just, let me find it. Of course, I can't read the tiny statute I printed off. Journal entries, complaints, plea agreements, jury instructions, and verdict forms. So in a plea, we don't have to present the plea colloquy. I'm not sure the court can take judicial notice of it underneath the statute. But what we have presented is we have the complaint, which was amended and has both provisions of the statute. We have the probable cause affidavit, which I think is part and parcel of the charging documents, at least we'd like it to be for our burden of proof today, which talks about this is a civil ongoing argument over a car. And it sounds more like impulsive bluster and Lindemuth type recklessness than a intentional criminal threat. It's not a domestic violence. It was in the course of an argument. We think based on the limited documents available, we've met our burden, or at least reached the burden where we need to go back and delve a little bit more, which this court can do under 68-14. The court may remand the case if there is a reasonable question as to whether prejudicial error exists. I know the state complained that we didn't add the plea colloquy, but the state could have added the plea colloquy if they wanted to, and they did not. They have the option under the statute to add additional materials to the record to show prejudicial error does not exist. So I think based on what we have in the complaint and the charging affidavit and the journal entries that we've added, we have shown that it is more likely than not a reckless criminal threat under the circumstances, so that we met that factual station.
What is the standard under that statute? So we have these three options. We say that the defendant has met the standard, the defendant has not met the standard, or we can remand. How do we determine whether remand is appropriate? I mean, it's whether there's a reasonable question, but we're on preponderance to nothing. Where is a reasonable question?
Judge, I think that's an excellent question of law for the court to resolve. I think a reasonable probability of a preponderance of the evidence is a pretty low burden when you combine those, and then it just has to, it's a reasonable probability of more likely than not. And I think if we're going to apply the rule of lenity to interpreting the statute and the tie goes to the runner, I think we got there. But I agree, there is some conflict between this reasonable probability language for remand and the preponderance standard. But again, I don't know that anybody's really challenged these specific provisions. They're not particularly old. And I think it facilitates substantive justice if we don't just say, nope, never mind, and we remand when we have these legitimate questions about, based on this, it looks like a reckless threat. Based on this, it looks like a reckless threat. Maybe it'll turn out not to be a reckless threat if we pull the plea colloquy, but we don't know. And I think it substantively favors the interest of justice to go back and answer that question, which we could not answer under the statute or in the pursuit of this appeal.
And that was one question I had. This was a 2009 conviction. what does a remand even look like at this point?
A remand would simply be to examine the plea colloquy and, depending on the scope of the other issues, but we'd just be talking about, have we shown by preponderance of the evidence it was a reckless criminal threat? What does the plea colloquy say? For all I know, he stood up and said he recklessly threatened these people in the course of an argument. Or maybe the state stood up and gave a factual basis that dove more into a police report that we don't have. And there's something else in there. So it would be a reverse or remand to examine whether or not the factual burden is met, whether it was a reckless or intentional threat, and then to sentence accordingly, depending on the outcome. I did note, we are asking for reassignment if the court remands this case, and I know that's not an usual request for remand. It's our position that the district court strongly disfavored post-conviction litigation based on some of his comments. And perhaps this is something I know because I actually litigated below. It may not pick up in a cold record, but it was very clear the court thought that his direct appeal should have raised this, and he did not want to delve into the facts of these issues. Part of the issue we have is that despite Murdaugh being clear law, the district court decided to apply PIPS, which was recently decided after sentencing. We are concerned that if we are remanded, if we don't have a very narrow or direct remand order, that we may not be able to have a fair proceeding below. So we'd ask the court to reassign. Other than that, I'd stand on my brief with the exception, I wasn't really going to get to this, but I think it bears a slight comment in my 1 minute. I understand with the misdemeanor convictions, the case law is not in my favor, but I think it does speak to a substantive problem we have. Municipal courts across the state impose 12-month penalties. And unless that defendant is advised, you can have appeal to district court and have your jury trial there. Defendants don't know, and it deprives them of that fundamental constitutional right to a jury trial. So I think that.
What would it look like? Because often at municipal court, there's not even a record. So
Correct.
how would what you're asking, like, how would that work?
I think it worked like Youngblood does. After Youngblood, there's now a box on every municipal journal entry. Did you have an attorney? Check here. I think that's what needs to happen in these municipal records. I'm not asking any court to delve into a plea colloquy in a municipal court. That's a non-starter. But I think it is important that municipal court records reflect the defendant was advised of the right to appeal and that they can access their right to jury trial through that appellate right. If we can't do that, then it does impact the fundamental right to a jury trial, which Kansas has already said, always said is structural. And we can't presume a waiver from a silent record. So if we have a box on a municipal journal entry that says advised of right to jury trial through appeal, and then that gets checked, no notice of appeal gets filed, then I think you can presume the waiver because they've been advised, sort of like a waiver of appeal. But without that record keeping, and given some of the comments in this record about how deficient the other proceedings were, I think that's the only way that we can fix sort of a systematic issue going forward where municipal courts are kind of turn and burn courts. We don't know if defendants know that they could have a jury trial or that the court told them they had a jury trial, which would be the court's responsibility. I think that's something that should be imposed similar to Youngblood. It just needs to be a box.
Any other questions from the panel? All right, you have 3 minutes for rebuttal.
Thank you, Judge.
Counsel?
The state's a little lost today. This case was litigated below. We're not raising an issue for the first time on appeal regarding reckless or intentional criminal threat. So I'm not sure why that statute is being cited, and it doesn't appear in the brief that a remand was requested on the criminal threat issue. As far as I can tell, rereading the brief very quickly this morning, she just asked for, Mr. Cox just asked for it to be remanded, to be resentenced without the scoring of the reckless criminal threat.
Do you think the use of that subsection first time on appeal should apply because the court didn't actually decide the issue, but decided it based on a misinterpretation of Murdaugh?
I do think that The question is whether or not there was an opportunity for it to be presented below. She could have presented, or the council could have presented the plea colloquy below to prove that this was actually a reckless criminal threat. I'm still on I don't think there actually needs to be a remand, even if you think that maybe a remand should happen to figure out if there's a reckless or criminal, because this has not been declared unconstitutional. The Kansas Supreme Court has apparently become very literal in its reading of statutes. It says that a crime has to be unconstitutional, and apparently, the fact that anyone changes his mind, like the United States Supreme Court has said that this is constitutional, doesn't matter. We know now that this reckless criminal threat, doesn't matter what it was in fact constitutional, but here we have an attempt. You have to have a specific intent, and you have to have an intentional conduct with an attempt crime. So with the attempted reckless or attempted criminal threat, it doesn't matter if it's attempted reckless or if it's attempted intentional. One, I don't think it was intentional reckless. I don't think attempted reckless. I think that's going to be very hard to prove because it is a legal fiction. There's nothing here that suggests that the parties were operating on any kind of legal fiction ground. I think the facts here kind of, even just from the complaint, establish some kind of attempted intentional. But regardless, you do not have.
The language in the complaint includes reckless language.
It does, absolutely. But you still have to have, for the attempt to work, you have to have the intent to commit reckless. And Boddicker itself was dealing with the fact that there was no specific intent. It was said reckless wasn't good enough. You had to have intentional. Well, the attempt fixes that because you do have to have that specific attempt. So I'm not sure, one, because it's never been declared, attempt criminal threat has never been declared unconstitutional. So I don't think the subsection even applies. But two, you have an actual intent that was the problem in Boddicker. So again, there's no issue.
So your argument is because reckless has been declared unconstitutional, but attempted reckless hasn't.
Right.
And so by adding the attempt, you believe that changes the constitutionality of the reckless portion?
Yes, because the entire thing in Boddicker was, well, first of all, more importantly, attempted criminal threat has never been declared unconstitutional. That crime itself has not been declared unconstitutional, which means the statute simply doesn't kick in. But here
But it's not the crime that is declared unconstitutional, it's the statute. And the statute on which it's based has been declared unconstitutional. Like the underlying statute with regard to criminal threat. Now, whether we agree with the analysis in Smith or not, it's binding precedent for us. And so that's kind of the way it goes. And that statute's been declared unconstitutional. I'm not sure how the state gets around that.
Because the plain language of the subsection says a crime defined by statute. Again, attempted criminal threat has not been declared unconstitutional.
But attempt isn't a crime.
It isn't, but I'm saying if the Kansas Supreme Court is going to be hyper literal, I don't see why we can't then continue to be hyper literal. If the Kansas Supreme Court has said one court has to declare it unconstitutional, no court to date has said attempted criminal threat is unconstitutional under either thing. And if the court were to actually look at the constitutionality, even if we pretended Boddicker was still good law, even though we know it's not based on Counterman, it's not unconstitutional because the concern in Boddicker was the whether or not there was an actual intent, and we have to have that intent with attempt. So I just don't see how we get to that. But
the fact that there's an attempt doesn't necessarily prove that it's intentional or that there was intent, because it can be a legal fiction. I mean, we know that that's permissible in a plea agreement to plead to a legal fiction. And you see it happen all the time. People attach attempt to a number of crimes. So if you separate, let's just set the intent portion of it to the side for a second and talk about reckless. Do you think the burden of proof has been met, and why wouldn't a remand be appropriate?
to be clear here, the burden of proof is on Cox. It's no longer on the state. So no, I don't think the burden of proof has been met. Cox has not proven that he only pled to reckless criminal threat. This to me is just like State v. Daniels. He pled, he agreed that his criminal history was correct, and he hasn't proven that it was in fact the reckless version. The reason I don't think a remand is appropriate is this issue was raised. And so I'm struggling to see how the subsection D that allows you to attach things applies here when this is not an issue being raised for the first time on appeal. I mean, I guess if you say, court, you should have had additional hearings, then okay, you can do a remand under that potentially. But it's still his burden and he hasn't done anything in the attachment to the motion to correct an illegal sentence to sit there and point out that this is why I get relief and this is how I meet my burden. So I'm not sure why there should be a hearing at this point.
No, we don't have a finding by the district court that the burden was not met. We just have a conclusion by the district court that Counterman controls.
Right.
So in the absence of a finding that we can review as to whether that burden was met or not, I mean, the district court never reached it. How is that something that we can rule upon?
And to the extent that that is the issue, I can say, I mean, if you're just saying there should be a remand because the court didn't make the right ruling and you don't have the ability to review it, that makes some sense. But I do think that as a matter of law, it is still Cox's burden and Cox didn't meet that burden. So I don't think that necessarily didn't meet it at the district court when he didn't attach anything to show that this was a attempted reckless. And I do think I understand that legal fictions can happen, absolutely. But you have to look to the elements themselves in the plea. We don't typically go to underlying fact. And as a matter of law, attempt requires a specific attempt. Or sorry, specific intent. So if the attempt, it has to, by law, under Murrin, it has to attach to each and every element. There has to be a specific intent here.
So we allow people to plead to things like attempted reckless murder. Like we allow people to plead to things that just, if this went to a jury trial, it wouldn't exist. And so.
But then how is that unconstitutional? If you can sit there and say there's a legal fiction, why are you then allowed to turn around and say, well, now this hypothetical thing isn't unconstitutional? It's never.
But attempted reckless murder has not been declared unconstitutional. The statute that would purportedly give rise to that hasn't been declared unconstitutional. We're in a different ballgame here.
Respectfully, I'm not sure you are, because the thing is, neither has attempted criminal threat. It has not been declared unconstitutional. The statute just says if the crime has been declared unconstitutional, this hasn't, because he chose to plead to the attempted version. So again, I don't think that you need a remand, but if this court is inclined to do a remand, I think it would just be because the district court didn't make the finding and needs to make additional findings. I'm not sure that an evidentiary, sorry.
With the same question I asked your opposing counsel about kind of where we've determined a remand is appropriate. Like in what instances does that reasonable probability kick in? And in what instances has a burden either been met or not? Like the statute gives us those three options.
And again, I don't think that statute applies here because this issue was not raised for the first time on appeal. Typically, when you get a remand, it is for things like what you said, where that you don't know how the court ruled. So there's not sufficient findings, the 165 type violation, you have to go back down and have more findings. If it's a factual issue, which then there has to be findings because this court can't make findings of fact. So those are the reasons we have a remand. I don't think that that subsection even applies here because this issue was raised below whether or not this should have been scored.
So then your contention would be any remand would be limited to the record already presented below.
I'm not totally sure on that. I mean, yes, that's my first position, is that a remand should occur for the court to insert whatever this court thinks the flaw in the ruling was, either additional findings or a fact finding. But
well, I mean, the court decided it incorrectly based on a legal analysis. It didn't look at the facts at all, right?
Right. But to the extent the court can look at the facts as they were pled and say there's no reason for a hearing, it's kind of like when there's a 1507 and this court says no additional findings need to be made, and you give the district court the option. Do you need to have a hearing? Do you not need to have a hearing? You leave it to their discretion. And so here, yes, the district court, as we now know, based on Smith, ruled incorrectly. And so you can, if you feel a remand is necessary, tell the district court, the remand, and you're either having to make additional findings or in your discretion, you can hold a hearing as you see fit. I do disagree that I don't think that there needs to be a new judge. I don't feel super strongly one way or the other about that, but I don't feel like we usually chastise judges for making incorrect legal ruling and then send it down to another judge. So I would stand on my brief on that. I don't think there are exceptional circumstances here that require a different judge, but it's not the end of the world to me one way or the other. I just don't think that this court should get in the practice of, I guess, punishing district court judges for making legal errors that are merely just legal errors. On the other issues, I do want to briefly talk about, I'm just going to stand in my brief on I'm going to call it the second issue, the challenges to 39, 43, and 44. But on 48, on that one too, I'm not really sure. It seems like the main challenge there is a lack of foundation type challenge. And I'm not sure I follow that, because here what happened is the district court had its, I'll call it a hearing, had a hearing, they talked about it, and then the state kind of realized, oh, hey, I can't tell if you use this record or not. Can we reopen? And to get around that, the parties stipulated, hey, we're just going to admit this evidence. So I'm not sure how then Cox can complain that that evidence can now not be considered. And I think that evidence says essentially, one, there's no jail time, so he never had a right to counsel. And two, he did in fact have counsel the entire time.
Cox hasn't claimed he didn't have counsel, correct?
I believe for the 48, that is his claim.
But has he done an affidavit or anything saying, I didn't have an attorney for this proceeding?
Not that I know of, no. And as to the upending case law and requiring more from municipal courts than we've ever required, and I don't know how long we have historically had municipal courts that have jury trial waivers, I do think that is an unreasonable request. One, not all misdemeanor courts have right to jury trial. So having to sit there and figure out, hey, do I have to check this box or not? You're probably going to have defendants think they have a right to a jury trial when they don't. So I think that can be very messy very quickly. It's not required. And more importantly,
municipal court judge should know if the person has a right to a jury trial if they're standing in.
but she's saying make a standard box that they check in each and every case. I mean, odds are there's going to be mix-ups. And even if there might be a theoretical right to counsel, if no jail is imposed, that right to counsel no longer exists for the purposes of collateral challenges. So I do not think that this court should get into the business of telling municipal courts, these are the boxes you need to check in order to have your convictions counted. And it is very clear from the United States Supreme Court in the state's opinion that the only collateral challenge is whether or not you had counsel and not whether or not your counsel was deficient in any manner, including that. And if you had counsel presumably would have told you about your right to jury trial too. If there are no further questions, the state would respectfully request that you affirm the district court.
All right, thank you, counsel. Ms. Ziegler, you have 3 minutes.
I agree that this is sort of a weird procedure for this case. We had a motion to correct a legal sentence, which was denied on procedural grounds. So typically when we have a claim denied on procedural grounds, we come back to, we come to the Court of Appeals, reverse and remand for more proceedings because you made a mistake on the procedural grounds. But this animal you get to raise for the first time on appeal. So I think the way the court should view the procedure of this is that it has the option to reverse and remand because the district court erred procedurally below. It also, because you can raise on the first time on appeal, the court could review the substantive nature of it and make a determination under 6814. I think it's two sides of the same coin, and the court can choose its own adventure for which procedure it would like to impose, because
Not only because it was just, it was denied on procedural grounds, or if the court had actually decided, actually, we also get to do this other one.
no, I think if the court had decided factually, then we've got a factual finding for the court to review for substantial competent evidence and to review the journal entries under the statute. When you deny a motion that can raise on the first time on appeal on procedural grounds, We get more options, I think is the way I would view it.
Do you have any sort of precedent for that?
No, but
I love it. We're making it here.
we're making, Judge, I love asking this court to make precedent. But
We love it as
We
well.
love it.
I know,
We
I know. But that's the way, I mean, that's the precedent for how you handle procedural issues. That's the precedent set out in the plain statutory language. And I think it's just this unique blip of a motion to correct a legal sentence based on all the jurisprudence. As far as not presenting the merits below, the case at issue was a Leavenworth County case. The court was asked to take judicial notice. It was cross-referred in all the pleadings below. So even though it didn't get to the substance, it still had access to all of these things. It was not asking the court to review an out-of-county case where we would need to attach journal entries. As far as the number 48, that's a unique issue because when the defense requested a record of that conviction, it got this abstract with no information. Then the state went and requested one, got a different abstract with this weird line in it. And then they went back and got a third one after the hearing or the morning of the hearing, I can't remember, and added it. And it really speaks to that municipal record keeping, that they're not a court of record, but they have to keep records if we're going to use them to verify convictions going forward. And it really reinforces that other argument on the misdemeanors. I mean, it is not, I disagree with the state. This court's job is to protect the rights of Kansans and rule on the issues before it. I think that case, or I mean, that entry alone really is illustrative of some of the problems you run into with municipal court records. And it is in the interest of all Kansans, it's in the interest of the state to make it easier to prove. It eliminates uncertainty to have municipal courts advise people of their right to appeal, their right to access a jury trial, whether that be a constitutional one for Class A or a statutory one for Class B or C. I think it's a pretty easy rule to say, just, municipal courts, you have to tell everybody you can have a right to a jury trial if you appeal and check the box. Unless there's any other questions from the panel, I would respectfully ask you to, well, I guess either reverse and remand or rule in my favor.
Other questions? All right. Thank you.
Thank you.
Thank you very much, both counsel. Thank you for your briefs and your arguments today. Excellently argued. We'll take the matter under advisement and